Thank you. Good morning. Please be seated. This is the time set for argument in our civil number 13-724, Jesse Olafson versus Brian Strong and the law firm. Each side will have 20 minutes in which to argue its position. The appellant may reserve a portion of that time for rebuttal, counsel, but you need to keep track of that time for yourself. We've read the briefs and conference of this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party or parties you represent? Counsel for appellant may proceed.
Good morning, Your Honors. May it please the Court. I represent the appellant, Jesse Olafson. I will reserve most of my time for rebuttal, absent any questions by the Court. I believe that this case is unique in that generally a Rule 32 proceeding is determined by actions or inactions of a defense counsel during the course of a criminal proceeding. However, the actions in this case occurred before a criminal proceeding actually commenced, and I personally couldn't find any cases because I'm unaware of any attorney that would actually convince his client to confess without a plea agreement in place.
What is it about Rule 32 that would preclude your client from raising a claim of ineffective assistance based on conduct that occurred prior to charges being brought?
Because the Rule 32 proceedings deal with the trial itself. The only thing that I could find that dated pre-trial but still during the criminal proceedings would be under State versus Draper if, for instance, a defense counsel failed to interview some critical witnesses prior to the trial, and it could be shown that that may have rendered that counsel ineffective. But there's nothing under the Rule 32. It deals with once the criminal proceedings start. And it's very clear that that's when Rule 32 kicks in. There's no way I could file Rule 32 if charges were never brought against an individual because Rule 32 wouldn't apply. There has to be a criminal proceeding.
But the language of the rule just says that, I'm looking at Rule 32, 32.1H. No, that's if there's anything that would have prevented, that would have kept the client from being convicted, but for this conduct he would not have been convicted, but for his unconstitutionally deficient representation he would not have been convicted of a crime. Why does that necessarily have to occur after charges are filed? Because,
again, I'm unaware of any mechanism. Rule 32 only applies in a criminal proceeding. It's one of the...
Is there a case that says you can't file that claim?
Beforehand, no, because as I said, if you look at the start of the criminal rules, I believe it would be Rule 4, there has to be a complaint or an indictment filed. That starts the proceeding. There was no complaint or indictment filed at the time of the malpractice.
I agree you can't have a Rule 32 if you've never been convicted of something, but you've been convicted. And you would agree that if it's a deficient investigation prior to trial, that's subject to a Rule 32.
Once it starts, that's correct, but not prior to.
But what's the difference if it's an hour before charges being filed or an hour after that he's deficient in his representation? He's already been retained. You're saying it's the magic point of charges have been filed, that you can't raise anything to do with conduct that occurred prior to the charges being filed?
Yes, because if you read under the Rule 32, you have to be successful on the Rule 32 and show that you would not have been convicted, which means you'd have to go to trial. The reason he couldn't go to trial in this case, and it was conceded by Mr. Strong, was that once the confession was in place, he could not have succeeded.
We allow Rule 32 though for pleas as well. You can argue that your counsel's ineffectiveness caused me to plead, but for my counsel's effectiveness. Doesn't that come up in a Rule 32?
I don't believe it generally does, because you would have to say something around the plea itself, failure to advise him of the charges or the consequences for Rule 32. It revolves around the plea itself, not around the rest of the attorney's actions. because you have to show manifest injustice in order to get out of the plea. And the way you demonstrate manifest injustice, for instance, if your attorney didn't advise you of the consequences, at one point under the Padilla, they didn't advise you of the immigration consequences, but it had to do and revolved around the plea itself, not any actions that were taken beforehand. I'm unaware of any Rule 32 that's ever been raised based on a plea because...
Isn't it necessarily actions that occur prior to the entry of the plea? It's the discussions with the client about this is why you should take this plea? Isn't that what?
Right.
Fair
it's
game?
part of the plea process, but we're not. There would be no claim of ineffectiveness once he's confessed. Any attorney would advise him under those circumstances, depending on how good the plea was, to take the plea rather than face literally the rest of his life in prison multiple times over.
But can't the same type of argument be made that there may be a benefit to you going in and confessing, assuming you actually committed the crime? There may be some benefit to cooperating with the police?
That was actually raised by Mr. Strong, and it ended up being inaccurate. And in fact, we had an affidavit from a...
my question is, why can't that be the subject of a Rule 32?
Your Honor, as I see it, I believe there has to be a criminal proceeding that's actually started and has to deal with the attorney's conduct once the criminal proceeding has commenced. I'm unaware of any case that I could find that indicates it can start prior to that point in time. Because otherwise, before he was charged, would Mr. Olofsson have been able to raise a Rule 32 claim before he was actually charged? My answer would be no, and I think that answers that question. A Rule 32 only deals with something once there are charges brought.
That's a different concept, Mr. Rain. Obviously, and I agree with you that you can't have a Rule 32 proceeding if you're not charged. But the question that we're trying to deal with is slightly different, which is once you're charged, and the criminal proceeding formally has begun, can someone raise, as part of that in a Rule 32 petition, can they raise some conduct of the attorney that would amount to ineffective assistance of counsel when the conduct occurred before the charging?
I don't believe so, Your Honor, and I'm referring specifically to Glaze versus Larson, and I actually quoted it. It said, holding that to bring a suit for legal malpractice that occurs, and then I boldface this, during the course of criminal litigation, a plaintiff must show that the proceedings in the underlying criminal case terminated in his or her favor, which is really the basis of a Rule 32 proceeding. So I believe those go hand in hand. This is a unique situation because it occurred before the criminal proceedings, and that's why I believe Glaze specifically refers to Rule 32. It has to be during the course of the criminal proceeding when the malpractice occurred in order to raise it under a Rule 32
You agree
proceeding.
the course of the criminal proceeding includes the pretrial discovery?
But not, no, it's not, if I said criminal proceeding and I did, I apologize. It says during the course of criminal litigation. And litigation does include pretrial discovery. It does not include anything that happens prior to the charges being brought. Litigation, criminal litigation, and the rules of criminal procedure only apply once there's formal charges
Let's say
filed.
someone has represented the defendant a week before charges are brought and then after charges are brought. He files a Rule 32 and he can only focus on the investigation if the attorney starts doing the investigation a week before charges are brought. He doesn't interview some people that would have been helpful. He continues in his investigation afterwards. I'm having a hard time figuring out why there's a bright line that's drawn on the day that charges are brought. It seems like the attorney's conduct would be fair game anytime, either before or after.
Well, based on the Draper case, State versus Draper, it is a fine line because in Draper it indicates that it's got to be trial counsel, and trial counsel failed to interview witnesses once the litigation commenced. So the appellate courts have already drawn that line. Otherwise, we certainly could have done it through a Rule 32, but we did not. I didn't handle the Rule 32, but did not see that as the proper mechanism based on specifically Glaze versus Larson. I mean, it says, it can't be any clearer than criminal litigation. And with all due respect, Your Honor, interviews done or not done prior to the charges commencing is not part of the litigation process.
Are you saying that a person could not get Rule 32 relief by showing that he was innocent and that the reason he was convicted was because his lawyer was less than effective pre-charging?
Yes, at least under Rule 32. I'm not saying that you can't bring a civil suit for malpractice, which, of course, I've done in this case, but I believe that you would have to show the attorney, once they were actually on the case and there were criminal proceedings, what they did during the criminal proceedings. I don't know how you, generally, if you fail.
Even if the petitioner showed actual innocence?
If he showed actual innocence, but what would it be based on prior to the criminal proceeding beginning? Even if there was a lack of...
Your guy, he says, I made these statements because my lawyer was ineffective, but they were not true and I was not righteously convicted. That would not be a good Rule 32?
Well, I can't answer that, but it's not the situation here. He admitted that he was guilty.
And your position is also that a person who's guilty of the charges that he was convicted of can bring this kind of lawsuit?
Yes. And I don't see anything in the case law that would say anything to the contrary. And while I understand it may be something that doesn't sit well, these charges would not have been brought. And there are many situations where cases are dismissed where it looks like the person's guilty because they didn't do the search warrant or didn't obtain a search warrant. So there are ways to have someone, and the court does allow for those situations where someone who very well may be guilty, and it appears to be guilty, maybe even admits afterwards that they are guilty, but based on the failure to properly follow the law or do what you're required to do, they are able to not be found guilty.
Your argument, as I understand it, is my client would not have even been charged.
Yes, sir.
But for his following the advice of Mr. Strong and going in and confessing.
That's correct, and that was known by the expert, and I can.
Did the police have any other evidence about implicating Mr. Olafson in misconduct with these victims?
The statements of the victims, but I can only tell the court the general course that follows in every one of these types of cases, which are unique criminal cases, is once the allegations are brought out, there's always a confrontation call, and then if there's an admission during the confrontation call, the person is arrested. If they're not, the next step is to try to get the person to come in and either talk to the police or take a polygraph or both.
So if the person doesn't come in and interview, so no, they're not going to come in. You're saying that, okay, in this case, you're saying there was a confrontation call that was set up by the police?
Yes, sir.
So, okay, so the confrontation call was set up by the police. So the police had allegations from the victims or their mother about Mr. Olafson.
That's correct.
Set up the confrontation call. He denies everything.
Yes.
They're then going to call him in for an interview, and you're saying that there is evidence in the record that if he hadn't come in for the interview, regardless of what this credibility of the children or any other evidence the police had, the police would not charge him.
Yes, and we have an affidavit to that effect. And that's the normal course in Maricopa County. And while I'm not certainly going to testify here today, since you've asked the question, I can tell you that is the normal course. I've had it happen repeatedly. They never get charged unless they admit during the confrontation call, unless there's other evidence, physical evidence or other things which were not present in this case, DNA or something else that is present, then they would do it, but not in this case. There was no independent third-party witnesses, and these were very young children. And those are some of the factors that I cited, and also what my experts cited. Someone who has done many of these criminal cases, including pre-charging. And I believe that was brought out in the affidavit.
So you're saying let's say we accepted your position that you'd be entitled to a hearing on this. You're saying that just the course of practice in Maricopa County would be dispositive of that there's no way that he could have been convicted or the charges would have been brought based solely on allegations by the victims? That's
correct. And actually, Mr. Strong, as I pointed out in his deposition, essentially conceded that as well. He's aware of that. And I actually cited, if you look in my brief, and I looked over it again today and last night.
Why would Mr. Strong be the person? Wouldn't we have to know what the county attorneys and how would a county attorney be bound by any kind of position someone has taken or by what the attorneys have thought over the years?
No, but I believe that if we brought in a county attorney, including the head of the sex crimes unit, Rachel Mitchell, she would concede that is their policy because, in fact, that is what they do.
So, would you say that that's the policy in every single case? There may be some victim that's just that's very credible, that there are no circumstances under which charges would be brought?
Not at that age. If you're talking about an older age, Your Honor, yes, it's possible, but not at the age of these particular victims.
Did anybody, and I didn't look at the entire record, I looked at most of it, but I didn't remember seeing any deposition of either the Ms. Mitchell or any of the police officer asking, gee, but for this confession, would you have charged?
I agree we didn't get to that stage once the motion for summary judgment was filed, but as I said, based on by my expert, my own training and experience, I would expect they would concede that. I know that to be true based on my practice.
So you're not saying you'd be a witness in the case?
No, sir. I said that's why I didn't independently file my own affidavit. We got an expert in this area to file an affidavit because I would agree that I would have to have someone else handle the matter.
Mm-hmm.
Thank you.
Thank you, counsel.
May it please the court, my name is Tony Vitagliano. I represent the appellees, Mr. Strong and the law firm. And before I start my presentation, let me just say, Your Honors, I think you've hit the nail on the head. Rule 32 states, quote, any person who pled guilty, ... shall have the right to file. And in fact, what the appellants seek this court to do is to go against two primary Arizona criminal procedure tenets that are paramount to the smooth running of the criminal justice system. Those two are, first, the Supreme Court held in States v. Spritz, 202 Arizona 1, that claims of ineffective assistance of counsel are to be brought in Rule 32 proceedings. This is so important to the smooth running of the criminal justice system that the court went out of its way in State ex rel Thomas v. Reyes, 214 Arizona 411, by the way, which does deal with a 32 in the plea bargaining stage. So there's plenty of cases dealing with that.
Post-charging, right?
Post-charge, yes, Your Honor. But in State XL Thomas v. Reyes, they reiterated that, saying, quote, a criminal defendant, quote, may bring ineffective assistance of counsel claims only in a Rule 32 post-conviction proceeding, not before trial, not at trial, not on direct review.
I agree with that, but are you aware of any case law, whether in Arizona or in other states, that specifically talks about conduct that occurred prior to charges being brought?
Well, contrary to what distinguished counsel has to say, we believe Glaze is right on point in that, in paragraph 24, where they talk about favorable termination of the criminal proceedings is an element of any action alleging malpractice, quote, in the course of criminal representation. And so they're clearly saying, and there's good reasons for this, of course. The same,
focusing on the word representation as opposed to criminal proceedings.
Exactly. Anytime during that criminal representation, the only time a convicted defendant can challenge his assistance of counsel is through a Rule 32 proceeding. And therefore, the exact same thing that counsel says he's concerned about, or plaintiff says they're concerned about, that is, if an attorney commits malpractice in the pre-charging stage, they wouldn't have any recourse. That's exactly what happens if you say that you can't bring that up in a Rule 32 proceeding, because the only time they can challenge it is in a Rule 32 proceeding.
But the element what we're talking about here is whether a Rule 32 proceeding, when there's a guilty plea, is required as an element of a legal malpractice action. I mean, Sprites and all those cases deal with, we're not going to let you raise IAC in the course of direct appeal or in the course of the proceeding, of the direct proceeding below. You've got to bring a Rule 32 petition. I think that all makes sense. But then the question is, if you do that, why is that a requirement for a legal malpractice action for conduct that occurs before the charges are brought.
In the Glaze Court, Your Honor, addresses that with the following reasons. First, and these reasons are true pre-charging through post-trial. First, the legal malpractice plaintiff has a burden of proof of proximate cause, requiring establishing that but for his attorney's negligence, he wouldn't be charged with the crime. They cite the Restatement 3rd, Section 53, Comment D, saying again that proximate cause in a criminal setting is an essential element of the malpractice claim. Second, a claim of legal malpractice requires more than just negligence by the attorney. It also requires actual injury or damage. Thus, without proving that the attorney's negligence caused the conviction, there's no evidence of proximate causation.
Why can't you do that in a legal malpractice action without a Rule 32 proceeding?
I'm sorry, Your Honor?
Why can't you do that for pre-trial conduct, for pre-charging conduct? Why can't all of that be proven as part of a legal malpractice action rather than a Rule 32 petition?
Well, the Supreme Court in Glaze says there's multiple policy reasons for that.
Right.
The concerns are that if you allow that to happen, that counsel might be disqualified from handling cases.
Of course, that doesn't apply when the counsel's already withdrawn.
I'm sorry, Your Honor?
In this case, counsel withdrew.
Well, counsel
So there's a
withdrew
malpractice
before the
action.
pleading.
Right.
One never knows what would have happened if Mr. Strong stayed on. And you know, that is true.
But the idea of creating a conflict between the attorney and the client based on a malpractice action in a criminal proceeding isn't present when Mr. Strong is gone.
That does alleviate it if the attorney steps down.
It seems to me, and this is analytically curious to me, but it seems to me the strongest point the Supreme Court made was that unlike civil proceedings, in criminal proceedings, we almost using the Rule 32 petition as a proxy for a legal malpractice, as a sort of a precursor of where things are going to go. Because it doesn't say they're exactly identical, but that they're identical, but rather that saying, well, the elements are very similar. You fell below the standard of care, and it might have affected the result. Is sort of like you fell below the standard of care and proximate causation. So it seems to me it seems to be the strongest analogy of why you do it, because, as the Supreme Court noted, criminal defendants tend to be very litigious.
That's certainly one of the.
That's one factor.
Yes, Your Honor. That's certainly one of the strong points that the court brings out. And again, they do that in discussing that the Rule 32 procedure is paramount important to the smooth running of the criminal justice system. Because
but that reasoning would apply, seems to me, would apply regardless of when the malpractice occurred.
Exactly, Your Honor. Exactly. And the Rule 32 is clear. I mean, you can't read any ambiguity into it. It just says any person who pled guilty or no contest, admitted a probation violation, or whose probation was automatically violated based upon a plea of guilty or no contest shall have the right to file a post-conviction relief proceeding. It's very clear that. And in fact, this idea about it only when the proceeding starts, first, that's a new argument plaintiff just rises, and of course the court could dismiss it based on that basis, but also it doesn't hold true. For instance, under Rule 4.1b regarding initial appearances, the rule says that it's when charges are filed or may be filed. And so that 4.1b clearly insinuates that once that has started, once there's an opportunity for charges, that the party is being defended. And it's clear under Rule 32 that...
How can you have initial proceeding if initial appearance if charges aren't filed?
If you give me 1 second, Your Honor, I got to pull that puppy up.
And if no one's charged anybody, how does someone file an initial appearance in the court?
Rule 4.1b states, Your Honor,
Well, you can certainly have an arrest and an initial appearance.
right?
And then the complaint comes back.
Yeah, and it says, Your Honor, initial appearance, first appearance before a court by a defendant for the purpose of advising the defendant of the charge or charges which have been or will be filed. So clearly, you can have initial appearance before charges are filed. And anyone who would, I don't think anyone would argue that if an attorney met with his client anytime before that initial charging, that wouldn't be part of the representation that Glaze applies to.
Well, Mr. Rainick's making that argument.
Well, other than distinguished counsel. Yes, Your Honor.
I hate to completely derail your train of thought, but what if this were a professional malpractice claim against a counselor, psychologist? There's no other evidence against the defendant except his confession. The victims have died, but he goes to his counselor. His counselor says, "You should really go confess." Does he have some sort of professional malpractice claim against the psychologist?
Only if he's complied with Glaze and has challenged that in a Rule 32
What
proceeding.
issue would he raise in a Rule 32 that would
The-
give him relief?
If I understand Your Honor's question, if something the counselor told him that caused him to
You have to
confess.
allege some kind of constitutional violation, ineffective assistance of counsel. You presumably don't have the right to effective assistance of a psychologist that you're consulting before you decide to go in and confess.
Well, the claim there might be, Your Honor, that he shared this with counsel, and counsel recommended that in light of that he do something, and he does it, and he alleges that that was a violation of his constitutional claim.
But I'm just saying, would he have a cause of action against a psychologist, a separate malpractice claim that you should never have told me to go confess?
I would argue no, Your Honor. I would argue that under Rule 32, under Glaze, it's clear that for the sanctity of judgments, for the validity of the claims, you have to have that conviction overturned or somehow have it ruled in your favor on a Rule 32 proceeding before you can then challenge malpractice for the conviction. If you're saying that, can I bring an action of malpractice against that professional outside of the conviction for just malpractice and treatment, that you could probably do. That you can
What
do.
he's doing here, he's bringing a malpractice action against a lawyer.
In the realm of his conviction, he's alleging that but for this lawyer's advice, I would not have been convicted. That falls directly under Glaze.
Well, that's because you're talking an IAC claim.
I'm sorry, Your Honor?
Ineffective assistance of counsel claim,
Exactly.
not ineffective assistance of counselor claim.
Yeah, I mean, it is exactly what Glaze is referring to, that if you're going to make a claim based upon poor assistance of counsel in a criminal matter, you need to go through your Rule 32 proceedings and have that reversed before you can bring a malpractice claim. Otherwise, concerns about the validity of the judgment, concerns about the ability and the desire of people to take on those jobs, that's challenged. And the court sees that as monumental in trying to deal with this and have time and time again said the only time you can attack a criminal conviction is through the Rule 32. And Glaze makes clear that if you're going to then challenge counsel in that conviction, you have to have gone through your Rule 32 and prevailed. As to some of the other things that counsel said, I can touch on quickly. As I said, Glaze talks about the criminal representation at paragraph 24, and clearly there's no evidence that but for his confession, he would not have been convicted. Mr. Strong says that he told counsel, of course, there's various things in the deposition transcript. One of the things is clear that he said, oh no, I said, based on what we've told, chances are you will be charged. But you know, you through more discussion, it is also clear that Mr. Olofsson did not make known to counsel that he had been that he had done this to other children, which obviously changes how the state's going to look at it. That comes out in his interview. And Mr. Strong had asked him, and he had told him, no, this was a first. Initially, Mr. Strong said he didn't do
How
it.
does that relate to whether Rule 32 petition applies to? Because that's really the issue.
No, I believe, that's one thing. I think there's an issue here as well.
But we would want to have if we get there, you would want to have a fact finder make that determination about whether that would have made a difference.
Well, Mr. Olofsson could very well have. He had assistance of new counsel. He could very well have still gone to trial, not plea bargain, gone to trial and claimed that his confession was tainted based on poor advice of counsel. And if the jury ruled against him, he could then make his Rule 32 proceeding. And he may have had that in mind, because he in fact did.
Is a confession inadmissible? Is a confession suspect if it's based on the poor advice of counsel, as opposed to being coerced?
He could have made that claim. I mean, he's seeking to have a same jury of those type people make a decision in a civil matter.
Sure, but what's the authority of a criminal in a criminal proceeding for a defendant to come in and say the confession's either inadmissible or suspect because my attorney misrepresented to me that if I confessed, I wouldn't get charged? How does that affect?
You're assuming, of course, that he then continues to admit that he did it. Initially, he says he hasn't done it.
Wouldn't he have to show that my confession was involuntary?
Yeah.
And that voluntariness doesn't seem to turn on accepting my counsel's advice to tell the truth. That doesn't.
That certainly makes a difference. I think he could have tried that. I think the reason they didn't is they assumed they still had a Rule 32 proceeding regardless. And in fact, he did seek to do Rule 32. He got 32.4C counsel who looked at the entire record, and as you know, under 32.4C, they have to look for any colorable claim, and they said there is no colorable claim. He then had 3 extensions to file it pro per. He ultimately decides not to file it. Clearly then, he can't, under Glaze, now bring that claim because he has not taken the advantage of having the court overturn that ruling as required by Glaze. As to the contract claim, there's no promise there. As the court cites, in a legal malpractice action, there's no claim for breach of contract unless there's a specific promise contained in the contract, and then only to the extent of the breach of that promise. He alleges, the plaintiff had alleged that the breach, quote, this is what he claims in his brief, the breach occurred when Mr. Strong set forth in the contract that no promises would be made about the outcome of the case, and Mr. Strong breached that agreement by making such a promise. In fact, that's not what the agreement said at all. The agreement said, quote, it is expressly understood and agreed that no guarantees or promises have been made about the outcome of your case. Clearly, that's not an expressed undertaking. Doesn't of a specific promise that would require a contract action. Any allegations that this standard of care opinion saves plaintiff's claims under Glaze clearly don't apply. And here, plaintiff is trying to take his malpractice claim, his tort claim, and turn it into a contract claim by alleging a promise that didn't exist in the contract and alleging that that was breached. If he has a claim, if he's alleging misrepresentation, which has not pled, but if he's alleging that there was this promise of something not true or whatever, that's a tort claim, that's malpractice, that would also fall under Glaze, and failure to have that conviction resolved in his favor would bar that. Your Honor, I'd be happy to respond if I missed any of your questions. I'd be happy to respond now. I have about a minute and a half. The wording of Rule 32 is clear. The wording of Glaze is clear. The whole philosophy behind Glaze is clear, that anytime during the criminal representation, if there's an allegation that the conviction would not have occurred but for the advice or the assistance of counsel, which you now claim was negligent, you need to have that conviction resolved in your favor through Rule 32 procedures.
Counsel, have you considered the possibility that what glaze actually means is you can't bring a legal malpractice action while you're still convicted? I mean, what Justice Hurwitz wrote is, principles of finality and respect for judgments have led, quote, most jurisdictions addressing the issue, unquote, to conclude that, quote, a convicted defendant seeking damages for malpractice causing a conviction must have had that conviction set aside, unquote, as a prerequisite to obtaining damages in a malpractice action. In other words, couldn't you construe what Justice Hurwitz wrote there as saying, whether you had a remedy under Rule 32 or not, if you're convicted and you stand convicted before the court, you can't bring a legal malpractice action?
I agree with you, Your Honor. I believe he is saying that, and he's saying there's a number of ways you can have that changed in your favor, and they go through that, and it's basically under the Rule 32 procedures.
I mean, it's called favorable termination in this opinion, and you can't bring, for example, a wrongful prosecution claim unless you had the criminal proceedings terminated in your favor, which means terminated in a way that indicates your innocence. So it's the language is certainly redolent of that. Malicious prosecution claims require basically an innocent defendant, or an innocent plaintiff, I guess.
And I think the court says overruled for a number of reasons, but clearly overruled. Thank you, Your Honor.
First, to answer the premise raised by Justice Thompson, I can give the court an example. What happens if the attorney tells, before litigation, says, I need you to destroy all the evidence because you might be charged. And then it turns out later that that evidence may have been exculpatory instead of inculpatory. So he may be convicted based on the advice of his attorney and not be able to prove his innocence. To answer the earlier question about the Rule 30...
The Justice Hurwitz's premise seems to be that it's respect for finality of judgments that's at issue here. And if the judgment is finally resolved in favor of a defendant's guilt, then there's a societal interest in not allowing collateral attacks on that. It's respect for judgments that Justice Hurwitz talks about.
And it's not a matter of not respecting the judgment, it's a matter of whether the attorney was effective. And to answer the previous question about why didn't we do this in a Rule 32, I believe the answer is very simple. And I believe that Justice Catney raised it. We can't go on a Rule 32 and kick out the confession. Rule 32s are, he didn't interview the witnesses. He was asleep during trial or on drugs. He didn't effectively cross-examine.
I was just saying you can't raise that at trial, but
right.
I'm not sure why can you not raise that as part of a Rule 32? My attorney's advice was bad.
Right. Rule 32 gets us back to the beginning. The confession is still there. And the fundamental problem I had from the beginning in this case when I was representing him on the criminal cases, it doesn't get the confession out.
But let me change the facts, though, that he's charged and then counsel is hired. Counsel tells him after that, you should go in and confess. You should go in and tell the truth. Are you saying that that cannot be raised as part of a Rule 32 proceeding?
It can, but the confession would stand because it's not in violation of Miranda, because his attorney would be there and make sure of that. And number two, it's not involuntary. So how does that confession get, in the criminal case, I'm talking about the criminal case, that confession will always stand.
But I want to take a step back. Now if we're just in a world where the charges have been filed, he meets with counsel, counsel says you should go and confess. If you cooperate, things will go better for you. Are we now not within the parameters of Glaze? This is representation during the criminal proceedings. Why would Glaze not apply to that situation?
It does apply, but that Rule 30, you're never going to be successful on the Rule 32 because of the actions of the attorney.
The fact that you're never successful doesn't mean that Glaze doesn't apply. That means Glaze applies and Your client doesn't get relief.
I respectfully disagree, because I think the difference is on a Rule 32, ineffective assistance, the idea is that it gets reversed because but for the actions of the attorney or the failure of the actions of the attorney, you get a new trial. You get to litigate it again. If you, in the situation that applied here, there was never going to be a trial because it would be, there is no way to kick out that confession. There's no legal way to say it was involuntary, because it wasn't, and you can't say that it was a violation of Miranda. So that confession will stand. There's no one that's going to find ineffective
That begs the
assistance.
question, though, of ineffective assistance of counsel. I think you can raise a claim that my attorney should not have told me to go and do this. That's ineffective assistance of counsel can be raised in a Rule 32, can be raised in a Rule 32 after a plea.
It can, but that you're not going to get a new trial based on that, and that's the.
But why not? Why not? If that's the if counsel was genuinely ineffective, guilt and innocence isn't necessarily dispositive. If counsel is ineffective, you can show that counsel performed below the standard of care required. You get relief, even though you in fact committed the crime.
No, you don't get relief, because I believe the court would find he was ineffective, but it didn't change the outcome because of the confession can't be overturned. That's the sticking point.
I thought your argument was that he wasn't going to be charged.
Well, I'm answering I don't disagree. That's been my argument all along. However, I was answering the questions that were asked, Jordan, that's why, because the first set of questions, why can't we address it in a Rule 32? Because the whole premise of a Rule 32, and it's something certainly we considered, even before I entered the plea, that confession was never going away, because in our position, Miranda rights were read, and he was with an attorney. There was no coercion. There was no promises by the police. There were promises by his attorney, but promises by his attorney don't. So we were never going to get past that confession. Even if we got it reversed, he'd still have that confession going forward for the next time. If Mr. Strong had been his attorney, he'd get a new attorney, but he wouldn't get rid of the confession. That's the fundamental problem.
I understand that, but it still seems to me that if there is a legitimate claim that this attorney, no attorney in the universe would ever recommend that someone go down and confess. Again, I'm talking about the world now after he's been charged. The attorney recommends that he go down and talk. It seems to me you could make the argument in a Rule 32 that advice, but for that advice, I would not have been convicted. That's independent of whether I'm guilty or not. That's the question. But for this negligent, that's deficient performance under the Sixth Amendment, under Strickland. But for that negligent performance, I never would have been convicted. Isn't that a viable claim in a Rule 32?
No, that's a viable claim in a legal malpractice case. In a Rule 32, it's not going to get you a new trial. So now that he's gone to trial, he's
not. Why does it not get you a new trial? What authority do you have for that?
Because there is no authority, as the courts, you fine justices have pointed out, there's no way to get that. There is no case that says if your attorney gives you bad advice and you confess that confession can be removed. So the next trial is still going to have that confession. So how is that going to help the client end up with an acquittal? It will never, because a Rule 32, the court's not going to rule, okay, that confession's out now because your attorney gave you bad advice. The only forum you have, unfortunately, but believe me.
How about if he fails to file a motion to suppress some evidence, and if there was something that he could have challenged, even though the evidence, you agree that the evidence is there, but there was just some basis that for keeping the evidence out.
That's different, Your Honor. It's completely different, because there was no legal basis for me to file to have that confession overturned. To me, that would have been a frivolous motion if I had said because of bad advice at counsel that confession should be kicked out. It would be improper. Believe me, if you guys want to rule that we can kick that out by bad advice of counsel, that'd be great.
You would ever kick it out of trial. I completely agree with you, but it seems to me it's a different inquiry about whether the counsel was ineffective in the advice that was given.
It's a hypothetical that, let's assume that you get ineffective. Let's assume the defendant is convicted based on his confession, and he gets 10 years, 6 years, whatever it is, and he files a Rule 32 petition, and the confession is all pre-charging. He serves a couple of years, files a Rule 32 petition, says ineffective assistance of counsel. I never would have confessed, but for my counsel's advice. If I hadn't been confessed, I wouldn't have been charged. And that might have, that would have clearly affected the result, because I wouldn't even been charged. And the court says, you know, you're right. So we're going to vacate your conviction and send it back down. They still got the confession. And the prosecutor says, for whatever reason, I'm not going to recharge you. You've served your time. We've decided not to recharge you. He doesn't have a conviction. He now stands without a conviction. So that could lead to a legal malpractice action, right?
I disagree. First of all, I think that scenario, Your Honor, in all due respect, would never happen.
State versus Fish. State versus Fish, he was convicted of, what was it, 2 years, he's got second degree manslaughter or second degree murder. We reversed the conviction. I mean, I authored the decision. We reversed the decision, and the county attorney, he had served 2 years in prison. The county attorney up in Coconino County said, I am not going to recharge him. We are not going to trial. We're going to get him released from prison.
But that's because the victim's violent propensities were going to be allowed at the trial. That's not what we have
Whatever
here.
Whatever reason, let's assume that the judge, I mean, I'm just saying, you said it would never happen. I'm saying that there can be situations where the prosecutor might say, you know, the guy served his time. He served some time. It's not worth going after him again. Even though we've got the confession, he served his time. We don't have that strong a case. And they might just not recharge him. And at that point, he stands without a conviction because of the Rule 32 petition.
Your Honor, I don't disagree with that, but I think the scenario here, because if he had gone to trial, he would have spent the rest of his life in prison. I don't think on the off chance that an appellate court might do something that we all agree this particular case has not come before, and learned counsel for the other side when I don't remember which justice asked him specifically, are there cases in other states that have ruled on this pre-charging? And his answer was no. He said he just tried to analogize to Glaze, which is obviously an Arizona case. I think that is the issue. And I don't think I think I would be ineffective if I recommended someone to go to trial under this court scenario on the off hope that if somehow the confession there was some issue with it, even though the confession stood in ineffective assistance, my client 2 or 3 years down the road might get a better plea than the 20 years he got. I don't think I could, under the law, I don't think I could do that.
On these facts, maybe perhaps. Okay.
Thank you.
Thank you,
Any
counsel.
other questions? Thank you.
We'll take the matter under advisement. We'll issue our decision in due course. Court's adjourned.